If you've just received an eviction notice saying you have to be out in 5 days, do not panic, but do act immediately. I'm attorney Vince Davis, and today I'm going to tell you exactly how to protect your home when the clock is ticking against you. In California, once you are served with an unlawful detainer, you typically have only 5 business days to file a formal response with the court. If you miss this deadline, the landlord can get a default judgment, and the sheriff could be at your door much sooner than you think. Step 1 is to look at the date you were served. This is when your 5-day countdown actually begins. Do not count the day you received it. Count 5 business days starting from the next day. Weekends and court holidays do not count toward this specific 5-day limit. Step 2. You must obtain the correct legal forms to file your answer. This isn't just a letter to the judge, it's a formal legal pleading. The main form is the UD 105. This is where you tell the court your side of the story and list your legal defenses against the eviction. You might have defenses you aren't even aware of, such as the landlord failing to make necessary repairs or retaliating against you for complaining. Gather your evidence now. Photos of the property, text messages, and emails to your landlord are all vital exhibits for your case. Step 3. Once your answer is complete, you must file it with the same court listed on the summons. You will likely have to pay a filing fee. If you cannot afford the fee, you can file a fee waiver request. This ensures that your lack of funds doesn't stop you from getting your day in court. Remember, you must also serve a copy of your answer to the landlord or their attorney. This is usually done by mail by someone over 18. You must then file the proof of service with the court. Without this, the court may not recognize that you've properly responded. Filing this answer is what stops the automatic eviction process. It forces the landlord to prove their case in front of a judge or jury. After you file, the court will set a trial date, usually within 20 days. This gives you time to prepare your full legal defense. Waiting even one extra day can be the difference between staying in your home and being forced out. The court is very strict about these deadlines. There are resources available to help you, from legal aid societies to court-based self-help centers, but you have to reach out immediately. I've seen many tenants lose their homes simply because they didn't know the rules or they waited too long to ask for professional help. One of the biggest mistakes is assuming a verbal agreement with your landlord will stop the court case. Unless it's in writing and filed, the clock is still running. If you do reach a deal with your landlord, it must be documented as a stipulation and filed with the court to protect your rights. An eviction on your record can make it almost impossible to rent another home in the future. This is about more than just your current apartment. You have rights as a tenant, but those rights only work if you assert them. Don't just pack your bags, stay and fight for your home. The legal system is complex and the laws are constantly changing. Navigating this alone while under the pressure of eviction is incredibly difficult. That's why we are here. We understand the urgency and we know exactly what steps need to be taken to buy you more time or win your case. Our goal is to ensure you get a fair hearing and that every possible legal defense is explored to keep you in your home. 5 days go by fast. By the time you've processed the shock of the notice, 2 or 3 days might already be gone. Many people get trapped by the weekend. If you get served on a Thursday, your time is almost up by the following Wednesday. Do not wait until day 4 or 5 to call for help. The sooner we start, the more options we have to build a strong defense. Whether it's negotiating a move-out date that works for you or taking the case all the way to trial, you need a strategy starting now. California has some of the strongest tenant protection laws in the country, but they are not automatic. You have to trigger them by responding. From just cause requirements to rent control limits, there are numerous shields available to you if you know how to use them. Don't let a landlord or their high-priced attorney intimidate you into leaving before you have to. You have a right to your day in court. Our mission is to provide you with the legal representation and peace of mind you need during this incredibly stressful time. Every situation is unique. We look at the specific facts of your case to find the best path forward for you and your family. We've helped countless families stay in their homes, and we want to do the same for you. Your community depends on stable housing. I'll say it one more time because it is that important. The clock is ticking. 5 days is all the court gives you to save your home. Pick up the phone and call us right now. Don't wait until it's too late to make the move that could save your tenancy. With decades of experience in the California legal system, we know the judges, we know the courts, and we know how to fight for you. Check the date, get the forms, file the answer, and most importantly, get professional legal advice immediately. Call us now at 888-888-6582. We are ready to review your case and start your defense today. The consultation is the first step towards security. Dial 888-888-6582 and let's talk about your situation. I'm Vince Davis, and we are all in this together. Call us now.